Good morning again. It is 10:03, so we are going to go ahead and get started with today's webinar. My name is Shanna Weber, and I am an environmental education specialist with the Environmental Assistance Branch here at the Kentucky Department for Environmental Protection. I said environmental like 3 times just then, and that was a lot of environmental. But we're super excited that you all were able to join us this morning as we learn a little bit more about what the process looks like if you were to receive a notice of violation from the Kentucky Department for Environmental Protection. Now, before I hand the presentation over to our guest speakers today and we dive into that topic, I do first want to do a little bit of webinar housekeeping, and then I'm going to give you just a short idea of what ECAP is and how we might be able to help you. So first things first, if you are here with us and you can hear me, you should be pretty much all set. Everyone besides our presenters today are going to be on listen-only mode, so you won't have access to your microphone or camera. But if you do have any questions at all throughout today's webinar, we do ask that you use the questions feature or the chat. We're going to be monitoring both. And we're going to try to get to your questions throughout today's webinar. There's a few spots where we're going to stop and ask for any questions. So feel free to put those questions in either the chat or the Q&A feature. With that being said, I do also want to let you know that today's webinar is being recorded, and I will be working on sending out the recording of the webinar as well as the PowerPoint slides from today within the next few days. So those will all be sent to the email that you used to register for the webinar today. So like I said, we're going to do just a little bit of an intro on the Environmental Compliance Assistance Program, or ECAP. And I'm going to say this, I could say it so many times, but if you take anything away from my short talk today about ECAP, it's going to be that we genuinely are here to help. Now, the program itself has two main objectives. The first is going to be to help businesses understand and comply with Kentucky's environmental requirements. And then our second objective is going to be providing free and confidential assistance to Kentucky's businesses. And we do this in a variety of ways. Now, ECAP actually acts as Kentucky's Small Business Environmental Assistance Program, or SBEAP. SBEAPs are requirements of the Clean Air Act. So for that reason, we are mainly funded by facilities' air emission fees. And again, for that reason, we do specialize in providing air quality assistance to small businesses in Kentucky. Now, small businesses do have a definition under the Clean Air Act. So they're going to be businesses that are less than 100 employees. They also must be independently owned and operated, and they cannot be a major source of air emissions. So like I said before, one of ECAP's major duties is going to be providing technical assistance. As I mentioned in that last slide, we do specialize in small business assistance, and specifically with questions related to air quality. Now, some of that technical assistance that we may do includes doing site visits, doing potential emission calculations, and specifically for small businesses, we can actually help develop full air permit applications and fill out any required forms. We can also develop record keeping and reporting spreadsheets for air permit requirements. So a good example of that is rolling total spreadsheets. We can help develop those. Now, Kentucky has actually opted to make our SB program multimedia, whereas some states may just focus on air quality. So we do staff a phone and email hotline to take in any requests or questions from companies and the general public. We can really provide a lot of general assistance in several water and waste topics, of course, as well as air. But we generally do get questions a lot about things like KPDES permits or questions about hazardous waste. For a lot of these areas, like solid waste, we aren't the experts and we know that. So we kind of act as a referral service, and we'll get you in touch with those subject matter experts. So if we don't know the answer to your question, we will find somebody who can best help you. We can also help facilities identify if any regulations are relevant, and we can recommend that they review certain regulations to see if they may be applicable to their facilities and their operations. So I've talked a lot about that technical side of our program, but we also do have an educational side, which is kind of what brings today's webinar to you. So we actually do a lot of different educational and outreach things. For instance, creating educational documents for the public. Now, this can be everything from quick one-page fact sheets on new regulations or regulation changes to I think we have up to, I think our longest is maybe 120-page manuals on every potential regulation that a facility in a specific sector might need to be concerned with. Now, all of these documents are going to be housed online in our resource library, which is going to be linked to this slide. So if you ever have any questions or want to see if we have any documents, chances are we do in our resource library. So feel free to always go in there and take a look. Now, we also hold training events and workshops like the one that you're attending today. So along with our ECAP RECAP webinar series, we are also hosting our Air, Water, and Waste 101 series, which is an introductory level workshop regarding air, water, and waste regulations. At the end of today's workshop, I am going to be putting up a slide with some of our upcoming events, so feel free to take a look at some of those, and we would love for you to join us. Now, so far, I have talked a lot about what ECAP can do, but I do think it is important to know what we do not do or what we cannot do. So please keep in mind that, like I said, ECAP as a program is non-regulatory. So this is just talking about our program in specific, not necessarily the speakers that we have, just what our program does. So ECAP does not issue NOVs, even if issues are seen during a site visit. I know today's webinar topic is all about NOVs, but ECAP as a program itself is not going to be a program that issues any of those. We do not make any sort of regulatory determination or give requirements as a program, but we do make recommendations to facilities. As I said, we have no regulatory authority, and we really are here to help. That's why we like to have events like today and be able to spread awareness and educate, facilities and the public. We also do not interfere with any inspector activity or anything that is covered in an inspection report. We have an enforcement discretion that I'm going to show in the next slide, and our enforcement discretion does not supersede anything that an inspector does. And then finally, ECAP cannot act solely as a corrective action or a remedial measure following an inspection report or an NOV. I think you're going to learn a little bit more about corrective actions later on in the presentation with our guest speakers. So ECAP cannot act solely as one of those. Now, we can assist facilities meet the requirements, but ECAP cannot be the remedial measure itself. So here's that enforcement discretion that I was just talking about in the last slide. I've mentioned a few times now our services are confidential, and we do not report on potential violations outside of just a few exceptions. The Department for Environmental Protection did create this enforcement discretion just for the Environmental Compliance Assistance Program. And the important part of this discretion is that any facilities that work with ECAP are given a reasonable opportunity to correct violations before they are ever brought to the regulatory agencies. Finally, I like to end my talk by giving some accomplishments that our program likes to share. On average, we have about 1,100 assistance requests per year, with 115 of those being detailed assistances. 54% of follow-up survey respondents are small businesses, and we've received a 96% positive rating from respondents, with 94% of our respondents saying that they would use our services again and recommend us to others. And 87% of clients make changes based on the recommendations that we give. So we like to just share some of those numbers because we think they are pretty awesome. Now, with that being said, if you do have any additional questions about ECAP or any of the services that we offer, feel free to reach out to our hotline that I mentioned earlier. At the end of today's webinar, I will have that number and email address on the screen. And that number and email goes directly to our ECAP staff members, and we would love to help you out with any questions that you have regarding any air, waste, or water regulations. But with that being said, I'm going to go ahead and turn the floor over to our guest speakers today. Chris Davis and Alexis Solfridge are environmental enforcement specialists that are located in the Division of Enforcement here in the Department for Environmental Protection. I'm super excited about today's webinar. It's one that I've wanted to host for a while now, and I think you guys will really enjoy and hopefully learn a lot and take a lot away from Chris and Alexis today. So thank you for joining. The floor is all yours.
Thank you, Shanna. We appreciate that introduction. Like she said, I'm Chris Davis, enforcement specialist at the Division of Enforcement Civil Enforcement Branch. And so, like she said, the topic of today is how to address an NOV. So let's start off by just what is a notice of violation? A notice of violation is a formal notification from the Energy and Environment Cabinet that a facility or individual has violated the Kentucky Revised Statutes regulated by the agency. So who usually issues these NOVs? It's either going to be from the Division for Air Quality, our Division of Waste Management, the Division of Water, or us, the Division of Enforcement. So what may result, or what NOVs may result from, are routine compliance inspections from the divisions for permitted facilities, investigations resulting from a complaint, and these can occur at both permitted facilities, unpermitted facilities, private properties, mining sites, just anything where a complaint or some sort of issue has popped up to where inspectors need to go out and investigate the situation. And also, they can be from a result of permit violations from self-reported data, such as submitting the discharge monitoring reports that we use for the KPDS program. And then the next few slides here, I'm going to let Alexis start us off here. But these next few slides, they essentially just kind of break down an NOV that you would see and just kind of go over each section here.
Thanks, Chris. Hi, everybody. So I thought that it would be really helpful to look at what an NOV looks like if you've never received one. There's pretty standard formatting, so there's some kind of important things that we'd like to point out that'll help guide you in viewing this NOV and figuring out how to address it as best as you can. So the first section here, you'll see a green arrow. That is the identifying information. We have redacted this particular NOV just for privacy's sake, but it's got a AI name, and then there are a couple numbers on there that we've also redacted. That is just for cabinet tracking of information for facilities, so we can look all this stuff up in our systems. The important thing to note in this section is dates violations are observed. So it is quite possible that an inspector observes violations while you're not there. So if you receive a notice of violation and you're wondering why, that will let you know when that occurred. Or if you receive multiple notices of violation, you'll know from when those violations occurred. Go ahead, Shanna. Okay. This next section here, you'll see that there are 5 violations on this NOV. And each violation section has 3 subsections. So I'm going to go over them real quickly. The first section there where that green arrow is the actual cited regulation. So if you'd like to look that up in context, sometimes it can make more sense for where that falls. So they're only going to give you that tiny subsection of where the violation falls. But if you want to look it up in context, that is where you'll find that. And then that second section there is the description of noncompliance. So that is going to be something self-entered by the inspector that describes how they observe noncompliance at your facility with that specific regulation. So this example here is not very descriptive, but others are. Sometimes they'll cite like a specific area of your facility. So the description part is really important. There could be more than one area. They only cite it one time, but more than one area that they're describing as being non-compliant. So that is where you'll find that information. And lastly, before we wrap up and do some other sections here, the required remedial measures and dates to be completed. Pretty self-explanatory. That's going to tell you how you are going to return that violation back to compliance. It will include some kind of specific measure, and it'll also give you a due date. So if you feel like there is an issue with completing that on time, pay attention to those dates, because there will be opportunities as we go through the rest of this NOV, you'll see to ask for extensions where needed. So we'll talk about that a little bit more, but that is the information that you're going to need to get back into compliance for only that specific remedial measure, or excuse me, that specific violation. So you'll see there's 5 and each have those 3 separate subsections. And then I'm going to let Chris talk about a couple other smaller sections in here that are just as important.
Thank you, Alexis. So she just went over all the violations, the sections, the 1 through 5. So at the bottom of every NOV, you're going to see in this little block here a disclaimer that's on every one of them. Pretty much just states that, these violations can carry up to a statutory maximum of $25,000 per day per violation, depending on the statutes and regulations that were violated. Also, in addition, violations may be concurrently enjoined, and compliance with remedial measures and their deadlines does not provide exemption from liability for the violations during the period of remediation, nor does it prevent additional remedial measures from being required. And then right there, the last section at the very bottom is the issuing agency's contact information. Pretty much it's going to have, what division issued it, the inspector or the contact person, their signature, their, email, phone number. It's very important that, you really want to reach out to them, establish a good form of communication. It just really goes a long way. To reach out, just kind of make contact, say, hey, we're in receipt of this, we've read it, we understand, even just saying like, and here's how we're going to address it. It just really helps. Like I said, it goes a long way. The best thing you can do is communicate with us. And then here's another quick example of an automated NOV. And this is mainly dealing with, as you can see, this is from our Division of Enforcement, our Compliance Assistance, our Compliance and Operations Branch, COB. This is what their NOVs tend to look like. As you can see there, we're pointing to the remedial measures section. Everything is very similar, same disclaimer, contact, statute, description, non-compliance. The remedial measures section, though, usually you will see them just say how it states here: the permittee shall comply with the terms and conditions of the KPDS permit. While that is very vague in general, again, it's a really good practice to reach out to the issuing agency. Here it would be our, Compliance and Operations Branch. And again, just kind of explain that, you're in receipt of this, you can ask them any questions you want as well, what this means, anything like that. Again, the big takeaway from this that we would like is just communicating with us. It goes a very long way with things like this. And then Alexis is going to take over here and break down how to respond to an NOV.
Thanks, Chris. So we have looked at an NOV, we've seen all the sections, how to read them properly. I'd like to talk a little bit more about how to respond to them appropriately. So we've divided it into 2 separate sections. These field NOVs are going to refer to anything that an inspector issues you after an inspection or an investigation on site. So air quality, waste management, Division of Water, These come directly from their field offices. So you're going to want to follow the remedial measure guidance specific to each violation. So please pay attention to that. Some violations cited are very similar, and the remedial measures may be the same for two notices or two violations in a single notice of violation. However, it's really important to recognize that even if they look very similar, the requirements to return to compliance for each of them may be different. And be cognizant of those due dates for the remedial measures. The information for the issuing agency is right there on the NOV. If there is an issue with providing a response to that inspector in a timely manner, just ask for an extension. We try to deal with things as civilly as we can without having to escalate things. So if there's a legitimate reason why a little bit more time is needed, just ask for it. It's better off to do that than to submit it late and the inspector has already submitted the case to the Division of Enforcement for escalated enforcement action. And then if you have any specific questions about the remedial measures themselves, please contact your inspector. They'll know exactly what you're talking about. They will be able to clarify. So it's better to ask those clarifying questions early. And then the next section we have here are D, E, and F NOVs. So these are ones that come from the Compliance and Operations branch. And they do some other permit programs as well, but the majority of their work is reviewing discharge monitoring reports through our automated system and issuing NOVs. So we're talking about KPDS permits for stormwater monitoring, for wastewater treatment plants, things of that nature. As Chris pointed out earlier, the remedial measure in those NOVs simply says to comply with the terms of the permit. And in a perfect world, yes, that's what we want for remedial measures. There is like a little hidden side quest here for COB NOVs, and that is to reach out to the Compliance and Operations branch. If you let them know that you're aware that there is one-off violations, or even if there's trending violations, let them know that you're aware of the problem, that you have been addressing it, or you have a plan to address it. They have a little bit of discretion about how long they wait before they refer a case to the Division of Enforcement for escalated enforcement action. And if they know that you're actively working to return to compliance, that may put that off for a little while. So like I said, and like Chris has said, you know, communication is the number one thing that we can promote in this webinar for how to respond to your NOVs. Okay, so at this point, you know, we have another little section to go over after, but now is the time that we would answer any questions that you might have so far. If you have anything that is facility specific and you don't want to get into specifics on a public webinar, you're more than welcome to reach out to Chris or I. Our contact information is going to be on the very last slide of our presentation, but I will let Shanna give us any questions that they might have gotten in.
Thanks, guys. I haven't seen any questions come through quite yet. And I do know I said that we're going to be on listen only mode, but I know sometimes questions are a little bit longer. So feel free to raise your hand and I can allow your mic if you do have any questions that you want to ask, because we do have the time to do that this morning. So we'll give it a few minutes and then see if any questions come in. It looks like we just got one. Will these slides be available? I can answer that one. So yes, I will be sending out the slides as well as a recording of today's webinar to all attendees. So hopefully by either end of the day today or tomorrow, you will be receiving those to the email that you used to register for the event with. am not seeing any more come through, but there will be a chance for more questions after this next section. So feel free. Oh, it looks like we actually got one. How many chances does a facility usually get before they are referred to the Division for Enforcement Actions? For example, too many NOVs for KPDES DMRs.
I can answer that one. Yeah, so it really depends. What Shanna had talked about before, enforcement discretion is not something that just ECAP has. All of our field offices, the compliance and operations branch, they also maintain an amount of enforcement discretion. Even the civil enforcement branch does. It depends on severity of the violations. So when you're looking at, for example, too many NOVs for KPDS violations of their DMRs, it really depends on if there are trending violations. There are two reasons why DMRs can be referred for enforcement action. It is numerous and continuing violations, which could be any one of them, or trending non-compliance with a specific parameter. But like I said, they do have enforcement discretion. So contacting them and letting them know, hey, we're aware we have trending TAN violations, and this is what we're doing to address it. They can withhold that referral for a little while before they refer it.
It looks like we got a few more questions come in. The next one is from Eric. What determines if a fine is going to be applied?
I think we should hold off on that because it's coming up.
We're going to
talk
be getting
about
into
it.
that here in a little bit.
Yeah. Thanks, Eric.
Yeah. So that one will be coming up soon. Hopefully we'll get that question answered for you. So we'll go ahead and go on to Crystal. When a condition violates multiple related regulations, is it acceptable to respond to all related violations with the same response if the remedial response satisfies all?
If that's
ahead,
the
Chris.
case, that's completely fine. Again, say, two violations are very similar, but, different statutes. That's why it's on there twice. If the remedial measure is going to clear both of those up at the same time, I just make a note of that, but it's perfectly acceptable to have the same remedial measure or solution for very similar violations.
Yeah, I mean, and your inspector should be able to recognize that, but certainly something you can point out in your response that this is a remedial action that we're taking, and it's going to address violations 3 and 5 of the cited NOV.
Let's
Yeah,
see.
like.
Oh, sorry,
Oh,
Chris.
sorry. So yeah, I mean, just the big takeaway is just, reach out to the person that issued it, your inspector, us, what have you. I mean, if you have any questions at all, they're going to be the best person to start with every time.
Awesome. Let's see. So another question, if there is a KPDES permit exceedance, does it help to provide an explanation in the NetDMR online submittal, or is it better to follow up directly with the Division of Water Compliance Group?
It certainly does. I would say every time that you have an exceedance, if you have a reason that it's happening, put it in the comments. I would say that if you have issues with trending non-compliance, that's when you really need to reach out to the compliance and operations branch. But when compliance and operations branch does review the automated program, they do look at those comments. So they are seen, and that is something that we would take into account as communicating to work towards compliance. Yes.
Our compliance and operations branch hugely appreciates when comments are left on DMRs. That is for sure.
And speaking of, we did get a question, is there a preferred means of communications? For example, email, letter, and phone call. And Marlon, the compliance and operations branch manager, said email, please. So do you guys have any further things you want to add?
Right from the source.
all are acceptable. Email is probably easiest to get a hold of pretty much anybody at state government.
Mm-hmm.
Awesome. And then we do have another question. I think this is the last one for now. Does the EPA do something similar to OSHA's voluntary protection program where they come out with you and help you to solve issues?
Haven't heard of that program.
Yeah, I've never heard of that either myself.
Can you throw that, can you copy and paste it in the chat so I can read it?
Yes, one second.
There we go. Okay. Does the EPA do something similar to OSHA's voluntary protection program? I would say ECAP would be the closest thing to that OSHA program. Now I believe EPA does have, I know they have a compliance arm. I specifically have not utilized them or had any facilities that have told me that they have utilized them. But Shanna's ECAP program does the same thing, and just at a state level as opposed to at a federal level. And you do have to keep in mind that we're in EPA Region 4, and it's headquartered out of Atlanta. It is sometimes hard to get federal help. So sometimes the best strategy you can have is starting at the state level, because we do have those programs available through ECAP. And Allison is correct. Yes, this is for small businesses as opposed to larger businesses.
Awesome. I'm loving the questions, so keep them coming in. But as of right now, it looks like that's all the questions we have so far. So if you want, we can go ahead and keep going.
Perfect.
Appreciate that, y'all. So getting into our next section here, referrals to the Division of Enforcement. So when resolution is not achieved through the issuing agency, the remedial measures are not addressed, what have you, they will usually get referred up to us, the Civil Enforcement Branch. That's where we're out of. And what we like to do are, so our two main goals here are returning everything to compliance and deterring future non-compliance. Those are our two main goals that we always try to achieve. So, you know, what might result in a referral to Division of Enforcement Civil Enforcement Branch? Pretty much, you know, continued or trending non-compliance, say, you know, DMRs are out for 3 consecutive quarters for, like, you know, permitted limits. You know, just facility practices might be, you know, just anything that shows that there's a trend of non-compliance and it's not getting any better. That will usually warrant a referral up to us. Also, what might warrant a referral is failure to address any of the violations or complete remedial measures in a timely fashion. I would say that's probably how we get most of our cases here in enforcement, is just the NOVs and remedial measures are just simply not addressed. They're not done, or just, you know, kind of just not completed. That's how we get most of our cases, I would say. And some other things that aren't on here, there might be times where an immediate referral is warranted. And this mainly comes from, you know, high priority violations or cases, such as if there's a high potential for a release, you know, oil into the water, some kind of, you know, accident or environmental emergency, violations of an egregious nature. Like I said, kind of like an oil release into a stream or a creek. Anything that causes concerns or can cause, you know, danger to public health and safety. And also, it can also just sometimes be special cabinet initiatives as well that will warrant immediate referrals. So we'll just kind of quickly break down kind of our process that we like to follow here when we receive a case. So what we like to do is when we get a referral, we will reach out to you all right away with a letter, phone call, whatever contact information that we are provided. We'll reach out to you, just kind of let you know, hey, your case has been up here. We let you know what's in review, what violations, documentation we're reviewing. And then we allow you all to send us some additional information that we might not be aware of while we're developing our case review. And then after that, we will schedule a conference. We like to call these administrative conferences. They can be either telephonic or in person. It's whatever you all would like to request. We're happy to accommodate anything that you all want to do with those. And these are usually informal. It's just sit down, both sides of the table. We kind of just introduce ourselves. We, kind of tell you why we're here, why we got this, what we see on our end from our databases and whatnot. And then we like to hear some additional information from you all. You can kind of fill us in on why those things might have occurred, or something that we're not aware of, or some other, circumstance that led to that. We very much like to hear that and discuss that at our administrative conferences. So like it says here, we go over the case background, the violations that brought us here, any remaining remedial measures that still need to be addressed. We will talk about that there and kind of a plan to address those. And then kind of after we discuss all that, we like to present our proposed settlement offer or resolution path. We like to usually go with two different types of documents, either a demand letter or an agreed order. Demand letter is a very simple, letter when things can easily be resolved. Remedial measures can be done within 30 days and whatnot. An agreed order is a legally binding document between both parties, and that's for most of the time long-term monitoring, such as if projects need to be done, or they're going to take a bid, or funding, or what have you. Anything like that takes a bit longer, we'll go with agreed order routes. And also, there usually is a civil penalty component when it does come to us. This civil penalty, it really is just, trying to achieve our second goal. It is a deterrent for future noncompliance is how we treat that. And Alexis is going to go ahead and kind of break down what factors we look at when we're assessing civil penalties.
Okay, thanks, Chris. So we do assess civil penalties in the civil enforcement branch. If notices of violation are unresolved and it results in a referral to enforcement, we will assess a civil penalty to deter future noncompliance. Now, how we calculate that and how we go about that has changed over the years. All of our environmental regulations hold a fine of between $1,000 and $25,000 per violation per day. And a lot of the violations that we deal with on a daily basis, Clean Water Act, the Clean Air Act, the Resource Conservation and Recovery Act, those are all $25,000 per violation per day fines. Now, the good news for this is a couple things. First, in 1994, there was a court case, Natural Resources and Environmental Protection Cabinet v. Wendell Maggard. And what came out of that case was that the cabinet was to apply certain factors when determining maximum penalties to assess. So what we'll do is we'll start by calculating a maximum statutory penalty based on how many violations there are, what type of category that they fall into, and how many days those violations occurred. And then we will apply the following factors here to take this statutory maximum penalty and bring it down. Okay. The first thing that we look at is the seriousness of the violation. That's pretty self-explanatory. Was there real or actual harm to the environment or public health? Looking at different volumes of unpermitted discharges. So it's probably one of the biggest, I guess, categories that we consider here. And then we look at if there was any economic benefit from the violations. Was there actually money made by committing these violations? We've seen that before. Is there money that should have been spent to avoid those violations that was not spent intentionally? It's just putting off those costs. We consider that economic benefit as well. But that's not always the case. And I would venture to say it's not usually the case that there is a lot of economic benefit to any violations. Something else we consider is economic impact of the penalty on the responsible party. So are we assessing a penalty to a Fortune 500 company? Are we assessing a penalty to a small town in Eastern Kentucky, to an individual? So we take that into consideration as well. You'll also see on there history of noncompliance, pretty self-explanatory. Is it your first referral to enforcement? Do I already know you? So that we take that into account, the history of noncompliance. So we'll look at number of violations, number of notices of violation, and number of enforcement actions in the last 5 years. Culpability, was it purely an accident? Was there negligence involved? So we take a look at that as well. And then good faith actions, if any. This is what our whole presentation is about. If you end up having your case referred to enforcement and you have been working with your inspector to try to return to compliance, that is where we're going to consider that for bringing the assessed penalty down from the very beginning. Okay, show us that you've actually been working to address the noncompliance. And then I believe Chris is going to finish us up on the rest of the processes. Did I miss anything, Chris? Oh, one important thing. Once we calculate that penalty, after we have calculated the statutory maximum and we've applied the Maggard factors, we will assess a penalty at the conference, but that is not the final number that we end on. Our penalties are negotiable. So what we'll ask is after the conference, we'll give a couple weeks. We'll ask that the responsible parties submit a reasonable counteroffer to the civil penalty and include justification as to why our director should accept a lower civil penalty amount for those violations. And these are the factors that we weigh most heavily, are the Maggard factors. So they apply to you. If they will look good in your favor for penalty reduction, include them in a response. So I think that was the most important parts of penalty, and I'll let Chris finish up on the rest of our enforcement processes.
Thank you, Alexis. And yeah, like she said, I would say the Maggard factors is probably that. I'd say that's the most important slide of our presentation here. Those factors is how we assess penalty, you know, everything there, good faith, what have you, communication. It all goes back around to those, I would say. So yeah, so thank you for that. So continuing the process, like Alexis had mentioned, we treat the penalty as a negotiated process. We go back and forth on that with our director, using your justification until we can reach a number that both parties are happy with. And we like to call this an agreement in principle. And from there out, you know, we will decide, like we both will decide what's the best course of action here. Either, you know, the demand letter, which I said that's usually for penalties and remedial measures that can be done very quickly. So, you know, we usually make them 30 days. If everything can be done within the 30 days, the demand letter is considered resolved and the case is closed from that standpoint. When it comes to agreed orders, like I had mentioned, they are a legally binding document between both parties. It's a bit more of a, you know, involved process, as in, you know, it's mainly for monitoring. If you all have projects that will take you a little bit more time, you know, upgrades to a facility, replacing blowers, what have you, anything like that. We will go under this case monitoring where you all will just kind of give us a what we call a corrective action plan, where you essentially submit a plan to us that you feel will get everything back into compliance and resolve the violations that were issued. Then, you know, throughout that monitoring, you just update us, you know, work the plan. And if everything, you know, works out, We get to the end of it, back into compliance, penalties paid, you've been submitting reports, the cap is, and we, close out the agreed order and the case is resolved from there. Now at the bottom there, you see escalated enforcement actions. This is what happens when we are not able to reach a resolution in the civil enforcement branch, or a demand letter is not fulfilled, or an agreed order is breached. That will call for escalated enforcement action, where we end up referring the case where we had it up to our Office of Legal Services, or if an agreed order is not being enforced, that can end up in Franklin Circuit Court to enforce the agreed order and its terms and conditions. So, I know you all won't go there, but that's just what will happen if we're not able to resolve the case here at Civil Enforcement Branch. Then, as the last slide says, we'll take some more questions here. And anyone on there, that's our Division Director, Jared Bell, myself, and Alexis's contact information on there. Like she had said earlier, and Jenna had said earlier, if you all have any questions, feel free to reach out to us, our director, and we will do our best to help you all out as much as we can.
With that, it looks like we have some time for any additional questions. So let's see if we have any come in through the chat or the Q&A feature. Let's see, it looks like we have one from Jean. What is the best way to check the status of any NOVs for a facility? I'm especially interested in making sure there are no open violations and all NOVs are properly responded to and all items are actually closed.
I would say, reaching out to the issuing agency or the inspector, like we had said earlier, is the best source of information for the violations that were issued, anything they saw at compliance inspections or incidents or anything like that.
I would also point out that if you are new to a facility and that's part of your job is to monitor notices of violation and you're new there, talk to your boss, but you can also put in an open records request with the cabinet and request to receive all notices of violation and inspection reports that have been issued in whatever time frame. You just have to specify whatever time frame that is. And then that way you can see what NOVs have been issued. And now the field offices do issue, what do they call them? Notices of sufficiency, letters of sufficiency. If a NOV has been properly addressed and they don't intend to take any further action on it, they'll issue a letter of sufficiency. That does not necessarily formally resolve the violations. They still might come back around in an enforcement capacity. If you're referred later for similar violations, they may come up in the penalty portion, but there will be no remedial measures associated with it. And it's something that we keep in mind, that if those violations have been resolved, we keep that in mind for penalty calculation as well. And the EPA has the same method regarding formal resolution of violations. So if there's anything out in the open, you're going to want to file an open records request or reach out directly to your inspectors. If your only thing is a stormwater permit, find out who your inspector is and ask them directly. If you've got multiple permits or you're generating hazardous waste and you have stormwater permits, might be easiest just to do an open records request.
Thank you. Eric mentioned earlier that Kentucky does have a self-audit privilege, KRS 224. So he said basically a facility voluntarily discloses violations and certain conditions are met, the cabinet does not seek a civil penalty. And we did have a question about that. I'm not sure if you guys would know the answer, but out of curiosity, can the certain conditions that Eric cited be summarized? Do you know what conditions? And Eric, I also allowed your mic, so if you have an answer to that question, feel free to chime in.
I don't know if Eric's going to chime in. Interrupt me if you do, Eric. So I've never had a facility or a responsible party invoke this type of privilege. However, if you copy and paste that particular regulation into Google, it pulls up everything. And if I can find it, voluntary disclosure, it talks all about all of these conditions, but they are very specific. So for me to sit here and try to summarize it right now for you all, that's not something I would be able to do. But look, there goes Eric. This is the same website that I pulled up. That's perfect. So if you would like more information about that, yeah, that's exactly it right there, that link that Eric provided. Thank you.
Yeah, I think it's under section 8. So
Okay.
Great, thanks, Eric.
you're welcome.
Next question. After a company formally responds to an NOV, how much time does the authority have to provide feedback or comments?
There's no designated time frame. We try to be respectful of your time and addressing things in a reasonably timely manner, but there is no timeline on that.
We will always usually. Oh, sorry. Go ahead.
Yeah, I was gonna say they will respond to you regarding those NOVs because they remain open and unaddressed in our system. So it's something that will continually come back to them like, oh, we need to close out this NOV or take further action on it, whatever that might be. But there is no official guideline on that.
Yeah, it'll still pop up. We'll still get bugged about it. So we're not just going to let it, be forgotten about.
And Marlon did mention that the Compliance and Operations Branch makes every attempt to respond within 24 hours with either acknowledgement of the NOV response or any additional questions. So
I would say most people here are very good about getting back to, the regulated community. So that usually will never be a problem.
Awesome. Let's see. We have another question from Jacob. For MACRD factors, like the previous enforcement cases, how far back do you guys usually look?
I believe it's 5 years.
It's 5 years. However, if a case was opened greater than 5 years ago, but closed less than 5 years ago, I will also consider that as well. So if the case, if the case was opened in 2018, but it wasn't closed until 2022, we're still going to consider that for history of noncompliance. And that's not to say that there's not another argument about what that history of noncompliance means. I know environmental health and safety managers change frequently. That's something you can use in your justification to just say, this role has changed hands. Information has fallen through the cracks about how to comply with particular permit conditions. So we will consider that for sure.
Yeah, the more information that we receive, it goes an incredibly long way. Like we cannot stress that enough. Because a lot of the times we don't see day-to-day operations. We don't know a lot of this stuff until, we have our very first informal administrative conferences. So if you can get ahead of it and let us know as much as you can, be as transparent as possible, again, it just helps so much with situations like this.
Yeah.
I think we say this every time we're talking to the public or any regulated facilities, that communication is one of the most important things that you can provide when working for us, like either with your inspector, with you guys, just communicate. It's so important.
Yep.
I am not seeing any more questions as of right now. But with that being said, like Chris mentioned, his email and Alexis's email are on the screen, as well as our division director, Jared Bell. And then if something happens and you can't find their emails and you have a question, feel free to email the Environmental Compliance Assistance Program and we will get you in touch with them as well. So there's always ways that you can get those questions answered. Always feel free to reach out. See, I'll give it another second and see if anything else comes in. Sorry, Chris.
Oh, no, sorry. And yeah, you know, if we don't know anything, we will always try to find somebody that can give you the information you're looking for.
Absolutely.
Okay, well, I'm not seeing anything else coming in. So if it's all right with you guys, we will go ahead and do our closing slides. But before we do that, we just want to thank you both for joining us today. I know I learned a lot with your all's presentation, so I'm hopeful that, you know, all of the other attendees were able to take something away and get their questions answered. So thanks for joining us, and we really do appreciate it.
Thanks for having us.
Yeah, appreciate you having us.
Of course. Let's see. So I'm going to go ahead and wrap us up today by just sharing a little bit more information. The first thing I do want to share is some of our upcoming events. All of these events are listed on our website. So our next ECAP RECAP webinar that we are having, or that is scheduled, is going to be October 8th, and we are doing a webinar on an introduction to PFAS in Kentucky. I'm really excited about this one. So we have Larry Hughes coming to talk about, you know, some things that the cabinet is doing and just give us an introduction. And then I also do want to mention that our Air, Water, and Waste 101 workshops are coming back for the fall, and we are doing this in a hybrid manner. So we are offering both in-person and online options to join us. So be on the lookout for that. We will be sharing information very shortly with the registration links and agendas and all of that additional information. And then finally, I did want to leave you all with the Environmental Compliance Assistance Program phone number and email address. Like I said, this phone number and those emails go straight to ECAP staff, and we're able to assist you with any questions related to air, waste, or water in Kentucky. So feel free to contact us, and if we don't know the answer, we will find somebody and get you in touch with somebody who will be better able to help you. With that being said, that's all that we have for you today. Thanks again to Chris and Alexis for joining us. We really hope that you were able to take something away from today's webinar and get some questions answered related to what to do if you have a notice of violation. So we hope to see you at some of our upcoming events soon and hope you have a great rest of your day. Thank you all.
Y'all have a great day.